So good afternoon, everyone. Great to be back with you again today at this great event to focus, I suppose, on a slightly different angle in terms of protecting children in the online world. So I'm going to talk a little bit about the international framework around children's rights and how it interacts with the GDPR, where the requirements for age assurance come in, both in terms of the data protection field, as well as under other EU level instruments that all interconnect in this space. So I'm going to start by looking at the UN Convention on the Rights of the Child, which is really a critical piece of the puzzle when you're considering children in the online and the connected world. As I mentioned, I'll be looking at the particular rules in the GDPR around parental consent and age assurance in the context of the age of digital consent, as well as the requirements for specific protection for children under the GDPR and how that connects with age assurance as well, along with some of the data protection regulatory guidelines that have been issued around Europe and important learnings from a number of really critical regulatory decisions that have been issued in the last number of years about processing children's data. So I wanted to start with the UN Convention on the Rights of the Child. This is a convention that dates back to 1989, and I think it's really fundamental to understanding this interlocking jigsaw of requirements around children in the online and the connected world in an EU context in particular. So the UN Convention is an international legal framework. It safeguards children's rights across the board, and nearly all of the countries in the world, including all EU member states, have ratified this. Certain countries, including the US and a small number of other countries around the world which don't have membership of the UN, have not ratified it, but it's almost a complete global ratification of the convention. And it's considered to be pretty much a complete and comprehensive human rights treaty in that it recognises children as rights holders because they're human beings like everyone else. And interestingly, the UNCRC, the convention has been referred to as a game changer in the way that we look at children, and that it moves away from the narrative that children are requiring of protection because they are vulnerable and weak. And instead, this convention really represents independent recognition of children's rights next to the rights of those who are responsible for them. So in other words, their parents and their guardians. Another important feature of this convention, which is really worthwhile pointing out, is that children are human beings in development. And so that means they have special characteristics. And while the convention refers to the rights of the child as a concept itself doesn't really exist because, of course, there's very many stages of development between newborn and adulthood and everything else in between. The convention itself is sometimes referred to as the 3Ps, which stand for provision, participation, and protection. And there's sometimes a fourth P that's referred to as well, which is for prevention, and that's, of course, prevention of harm and risk. The participation piece is about the convention's recognition of the evolving capacities of the child, and that parents also have a duty to guide and direct their children, and that those duties and that involvement of parents in their children's lives has to be adapted in accordance with their child's development. In terms of the overall kind of framework and structure of the convention, it's supplemented by guidance called general comments, and they are issued every year or two by the Committee on the Rights of the Child, and that's the body that is tasked with monitoring country compliance with the principles set out in the convention. And these general comments that are produced by the committee, they're not binding as such on states that have ratified state parties. But as I'll come to talk about, they are influential on governments, on policymakers, on state authorities, as well as regulators and advocacy organisations. And that's really because the convention itself, it's part of the legal order of nearly every country in the world, all those countries which have ratified the convention. And so while these general comments of the Committee on the Rights of the Child, they're not enforceable per se, the UN convention itself due to its ratification means that the comments of the General Committee are an important part of the broader international legal backdrop to children's digital rights and issues. And of course, this equally applies to children's data protection rights, privacy rights, and protection in terms of online safety in an EU context. And this is important because the UN the UN Convention on the Rights of the Child is really the anchor for regulators when they are navigating the application of children's rights against the principles of the GDPR, and indeed, as we'll come to see, against other principles of new emerging legislation across the EU. And in fact, as I'll come back to as well, the UN Convention on the Rights of the Child is becoming increasingly referenced directly in EU legislation, and I think this is a very important and interesting trend. One general comment that I do want to mention is number 25, and that's the general comment on children's rights in the digital environment. And this is a document which has been referred to by regulators in their own interpretation and application of the convention, insofar as it applies, for example, to the GDPR and how to interpret children's rights as data subjects under the GDPR. And it basically takes this general comment takes the rights from the convention and it places them against a digital backdrop to explain how the entire spectrum of rights within the UN Convention on the Rights of the Child actually has a digital dimension. And Jutta, who's sitting in the second row, has very kindly mentioned to me that she has brought hard copies of General Comment number 25 along for anybody that might like to have a look at this really important topic. And it is the one piece of reading that I would recommend for anybody here today in terms of understanding this broader framework for children's international rights. So before we get into a little bit more detail around the principles from the UN Convention on the Rights of the Child, it's very important to be clear about who a child is, because this is a relevant issue when we come to all sorts of EU requirements under different legislation. So Article 1 of the UN Convention on the Rights of the Child says that a child is someone under 18 unless under relevant state law majority age has been attained earlier. So generally speaking, the starting point is that the special protections of the convention must be applied to all under 18s unless you're dealing with a country where its national law specifies that you reach adulthood earlier than 18 years. There are 4 articles from the Convention that the Committee on the Rights of the Child has identified in another general comment, that's number 5, as being of particular importance as to the overall interpretation of the Convention. So the Committee calls these the general principles of the Convention for interpreting and implementing it. And really, they say that these should be applied when interpreting the entire spectrum of the rights of the child that are set out across the Convention. And the Committee on the Rights of the Child has also said that these 4 principles should really serve as a guide for working out what measures need to be taken to realise children's rights in any situation, including in the digital space, which is of course what we're focused on at this conference this week. And the 4 core pillar principles of the Convention, I've put them up on the slide. They are firstly the principle of non-discrimination, so that's Article 2, and that means that all children should be treated equally, and that's regardless of their background, regardless of the actions of their family or their parents. And so this covers a really broad range of issues, including digital exclusion, as well as the discriminatory effects of profiling, discriminatory content, and communications like hate speech. Then we have what is probably the most famous of all of the articles in the UN Convention on the Rights of the Child, and that's the best interests of the child principle, Article 3.1. And in fact, the UN Committee on the Rights of the Child has produced its own separate general comment dedicated solely to this principle because it's really fundamental to understanding the whole framework. And basically this principle means that in all decisions that are taken about children, the best interests of the child should be a primary consideration. So it's not necessarily the paramount and sole consideration, but it must be a consideration. Then moving on, we have the right to life, survival and development that's set out in Article 6 of the Convention. And of course, that can very much have a digital dimension, particularly when we're talking about online safety and online harms. And then finally, we have Article 12, and this is the right of the child to be heard. And this is really about the principle of participation that I mentioned earlier, in that every child who is capable of forming their own views has the right to express those views and to have those views given due weight in accordance with their age and maturity, according to Article 6. And I think this is a really important consideration in the context of children's online lives and their right to data protection and privacy in particular, when we're talking about the extent to which parental intervention or parental involvement are permissible. So while these 4 articles that I've mentioned are considered to be the key principles of the UN Convention, when we're talking about the digital environment, there are quite a few other rights from the Convention which are going to be really relevant to children's use of online services. And I put some of those up on the slide. And again, these are mentioned in general comment number 25. So you can see that these span the right to identity, to freedom of expression, freedom of thought, the right to access information from the media, the right to play, which the UN Committee has recognised as including digital and online play. And in fact, there's a separate general comment on that issue as well. Importantly, there's also the right to privacy, and the Committee on the Rights of the Child has said that children have the right to privacy from their parents too, depending on the context. So I think that's a really important angle to bear in mind when we're thinking about children, digital interactions and data protection in particular. So I mentioned earlier that the UN Convention on the Rights of the Child explicitly recognises the important role of parents and legal guardians and those legally responsible for children. And as you can see from the slide, there are numerous articles across the Convention which give effect to the unique position of parents, including that states are obliged to respect the rights and the duties of parents, and the fact that parents have primary responsibility for the upbringing of their children. But as you can see from some of the articles that I put up on this slide, Article 5, 14, 18, parents' rights are not untrammelled. And parents' rights essentially have to give way to the best interests of the child. So it's not about the best interests of the parent. Another important point to make, I think, is that parents' responsibilities must be exercised in a way that is consistent with the evolving capacities of the child. And really, this is about the child's gradual acquisition of understanding, of competencies and of agency as they develop and mature. And the committee has said, going back again to general comment number 25, that this is particularly important in the digital environment because the risks and opportunities for children will change with different ages and stages of development. And that's in fact a phrase that you hear used a lot in the children's rights landscape, ages and stages. So all of these considerations really should inform how measures are designed to protect children in the digital world and to facilitate their access to digital services. So I think this is just a really kind of interesting backdrop to the conversations that we're all having over the course of these few days. Here we have the UN Convention on the Rights of the Child exerting a really significant influence when we're talking about parental controls and permissions, which are of course all inextricably linked with issues around age assurance. And in that particular context of age assurance, the Committee on the Rights of the Child has said in its general comment number 25 that robust age assurance age verification systems should be used to prevent children from acquiring access to products and services that are illegal for them to own or to use, and that age verification systems should be consistent with data protection and safeguarding requirements. So again, the UN Convention's reach extends right into this whole world of age assurance that we're exploring. So now I want to turn to look at the treatment of children in EU primary law. And this is important because EU laws that speak to the protection of children include the GDPR, as we've mentioned, the Audiovisual Media Services Directive, the Digital Services Act, even the brand new AI Act, which hasn't even had its text finalised yet. These are, of course, all EU legal instruments, and so they have to be interpreted in a manner that's consistent with the primary law of the EU. In other words, with the EU treaties and with the EU Charter of Fundamental Rights. So you'll see on the slide the provisions of the Treaty on the European Union, which basically commit the EU to promoting protection of the rights of the child. And this principle is reinforced in the Charter of Fundamental Rights of the European Union at Article 24 of the Charter, which guarantees the protection of a variety of rights of the child, including the right of the child to express their views freely, to have their views taken into consideration in accordance with their age and maturity on matters which concern them. And here you'll remember the parallel with Article 12 of the UN Convention of the Rights of the Child on this topic. And then importantly, Article 24.2 of the Charter also guarantees that in all actions relating to children, whether they're taken by public authorities or by private institutions, that the child's best interests must be a primary consideration. And the explanations to the Charter of Fundamental Rights expressly state that this Article 24 is based upon the UN Convention on the Rights of the Child. And in addition, then, we have also had the Court of Justice of the EU recognising in its case law that the UN Convention forms part of EU law. And even at a national level, say in Ireland, where I'm from, the Irish courts have recognised this influence as well. And so all of this really means that the UN Convention on the Rights of the Child and the full range of rights that it bestows on children must always be kept in mind when you're specifically looking at children's rights and protections in the digital environment, including in connection with the GDPR, with the DSA and other national laws around online and digital safety. So as you're probably aware, and as I've kind of referred to in passing earlier, the GDPR recognises children as data subjects with data protection rights of their own. There's a total of 25 references to a child or children spread across the GDPR. And as a text, it talks about the specific protections that children merit because they may be less aware of the risks, consequences, safeguards and their rights. And that's kind of a quote from Recital 38, which is really the seminal reflection of the GDPR's approach in this respect. So I'm not going to get into a very detailed analysis of the provisions of the GDPR which deal with children, and that's particularly because there's a fantastic presentation coming later from Jenny Dolan of the Irish Data Protection Commission, which is going to focus on some of these issues. However, I did want to point out what I see as really two threads that are running through the GDPR's special treatment of children, and I think that these are arguably illustrative of two distinct philosophies that you can track back to the protection and participation aspects of the UN Convention on the Rights of the Child. So firstly, there's a kind of a paternalistic or protective approach. So for example, the GDPR identifies various processing activities which are considered to be more risky to children. And according to the terms of the GDPR, they should not involve children's personal data. And there are things like automated decision-making, including profiling, marketing, and the creation of user and personality profiles. And then at the other end of the spectrum, on the empowerment side, a good example is that the GDPR says that children must have privacy information tailored to them in a way that they can understand what is happening to their personal data. And again, this is about empowerment and participation and really helping children to exercise their GDPR rights as autonomous rights holders. And some of you may have been present in the room for the great discussion that we had this morning around transparency, particularly for children in the context of age assurance solutions being deployed by online services. So I also wanted to briefly point out the influences of the UN Convention on the Rights of the Child on some of the guidelines that have been produced by European data protection authorities to show how regulators, essentially as organs of the relevant member state, which is a party to the UN Convention, have applied the UN Convention in line with the state's obligations under that convention. So the UK, the Irish, the Dutch, the French, the Spanish guidelines on processing children's data, here they all specifically reference the UN Convention on the Rights of the Child and or the best interest principle, which I think is a really kind of powerful illustration of the reach and the influence of the convention. And I think it's going to be really interesting to see whether the EDPB guidelines on children when they come out will take the same approach that some of these individual member states have taken to the influence and the interpretation of data protection rights under the UN Convention on the Rights of the Child. As regards the need for age verification or age assurance, I think it's important to kind of pick up on this point as well, of course. And many of the European data protection regulators, including those that I've just called out, and have mentioned on the slide, they either specifically or impliedly call out the need for age verification, including the Swedish, Norwegian and Icelandic authorities as well. And of course, we heard from Jenny Dolan at the Irish Data Protection Commission earlier this morning about a statement which will be forthcoming from the European Data Protection Board within the next number of months about the use of age assurance in a data protection context. And that's going to be, I think, a really interesting and an important development on this whole landscape. I also wanted to very briefly reference some Data Protection Authority enforcement actions concerning age verification. So in terms of the cross-border processing element and the co-decision making, which happens at a European Data Protection Board level across Europe, we've seen two major decisions, both of them involving children's personal data, one in connection with Instagram and one in connection with TikTok, emerge over the last number of years. The EDPB decision which was originating with the Irish Data Protection Authority involving TikTok is important in the context of age verification, particularly when you consider that alongside another decision which came from the ICO, and both of these decisions were made in 2023. And really read together, I think the key takeaway of these two, the ICO and the DPC decisions, is that the use of age gates or self-declaration methods as means of preventing underage access to a platform will essentially infringe one or more provisions of the GDPR. It's also worth mentioning as well that there have been some temporary bans imposed on generative AI-based applications by the Italian Data Protection Authority, the Garante, in connection with Replica and ChatGPT. They were temporary bans and across Italy, which were then lifted. But one of the kind of key concerns that the Garante had expressed in connection with those bans was the lack of age verification measures to prevent under 13s accessing the services in question. So again, we're beginning to see, I suppose, a kind of a pattern of Data Protection Authority enforcement actions, which are focusing on age verification and age assurance as an element of the different protections for children that are being looked at in those decisions. So I also wanted just to briefly point out some legislation in the digital regulation space where there's been I suppose a legislative trend referencing children's rights principles that come from this international UN convention-based framework within the actual text of EU instruments. So the GDPR itself does not reference the UN Convention on the Rights of the Child, but the Digital Services Act has multiple references to the rights of the child, to Article 24 of the Charter of Fundamental Rights, which, as we mentioned earlier, comes from the UN Convention. And the DSA also mentions the best interests of the child principle in its various provisions, which address protections of minors. And I put some of those up on the slide. The Audiovisual Media Services Directive also references the rights of the child under the Charter of Fundamental Rights. And I think also a really important and very recent development, which has pretty much gone unnoticed, is that within the EU's AI Act, it specifically references General Comment number 25 in its recitals. And I think that's a really potent demonstration of the reach of the convention itself. And also, I suppose, the influence of the UN Committee on the Rights of the Child as the oversight committee for the convention. And it's all the more striking, I think, when you consider that the committee itself doesn't really have any legal teeth to enforce its comments, but still we see the influence spreading the whole way to the EU and to new legislative developments. So overall, I think it's really clear that EU law and policy on the protection of children in the digital world, it's all very tightly wound up with international law on the rights of the child. So finally, before I finish up, I just wanted to outline a sample, but certainly, and I would stress this, it's not an exhaustive list of the different types of regulatory and legislative developments where there are requirements to carry out age assurance or age verification in the digital landscape. And what I put onto the slide are some requirements which are obviously in addition to the very clear express requirements to prevent children from accessing services and products which can only be supplied to over 18s, like pornography, gambling, sale of alcohol, etc. So First of all, there's parental consent as a form of consent for the processing of a child's data under the GDPR. So as you're, I'm sure, aware, where a service provider is relying on consent as the legal basis under Article 6 of the GDPR for processing children's personal data, then that service provider is going to have to identify children who are under the relevant age of digital consent in the country concerned, in order that they can then, as a follow-on step, collect the parents' consent to process that underage child's data in connection with the delivery of the online service. Secondly, there's the second kind of bucket of requirements, I suppose, around deploying age assurance or age verification is the specific protection which the GDPR calls out that children merit in connection with the processing of their personal data. And I do want to stress that this is a separate and distinct issue from the issue of legal basis under Article 6 and the requirement to collect parental consent under Article 8 of the GDPR. So essentially the second kind of requirement means designing services that are used by children with specific protections for them in mind, because the GDPR requires that children benefit from a specific, in other words, a special level of protection over and above adults. And this type of approach is, of course, advocated by various regulators which have come out and produced significant guidance in this area. So the Irish DPC in its fundamentals, the ICO in its children's code, which is about age appropriate design. So obviously, in order to ensure that you apply certain higher standards of protection through your default privacy settings and features for child users, you will first need to identify who those child users are, so you can send them through a different journey to that which an adult user would experience. Then you have other EU legal instruments such as the Digital Services Act, the Audiovisual Media Services Directive, which is of course implemented at a national level around Europe. And again, we're seeing age assurance requirements either being explicitly called out as needed by the legislation, or else they're a necessary implication of a stated requirement to protect minors. So for example, to protect them from harmful content under the Audiovisual Media Services Directive. And then interestingly, looking ahead to some further legislative initiatives which are kind of in the pipeline, the proposal on a regulation for combating child sexual abuse material may also contain similar sorts of requirements in the context of the European Digital Identity, the eIDAS 2 regulation. The European Commission may end up issuing standardisation requests on a European standard for age assurance or verification to support the development of an EU-wide digital proof of age. Also, potentially, there will be an EU-wide age-appropriate design code, as the European Commission has indicated in its Better Internet for Kids Plus strategy as well. So lots and lots of developments happening at an EU level, where I think we're going to see more and more of this kind of proliferation of the requirement to conduct age assurance or age verification. Finally, then, there's a smattering, albeit a growing smattering, of national law requirements which are connected to online safety, where age verification or age assurance is a kind of a necessary corollary of those sorts of legal requirements. So, for example, the Online Safety Act in the UK, as well as the Online Safety and Media Regulation Act in Ireland, and forthcoming online safety codes under that Act. You also have various new and existing laws in countries such as France and Germany, which require age verification in connection with parental authorization and parental control features. So I suppose clearly the message today is that there's a jigsaw of EU and national and regulatory guidance which requires, to a growing degree, age verification and age assurance, and I think that trend is really set to continue. So I'll finish up on that note. I hope this presentation has given you something of a sense of how all of those sorts of requirements and legal regimes kind of fit together alongside the international framework for children's rights under the UN Convention on the Rights of the Child. Thank you.
Thank you so much, Anna. Just as a reminder, we do have a few hard copies of General Comment 25 up at the top. So if you'd like one, wave at me and I can give them.